Okay, good morning, class. This is going to be your mock number 2 final exam. This is going to be 1 minute at 180, and it's for warm-up, okay? Mock number 2. So make sure you label them properly if you type them up. Here we go, mock number 2 for 5 minutes, and it's 180 for practice. This matter came before me on the 10th day of August, 1978 for a hearing on a notice and motion to strike. From a review of the pleadings, it appears that the plaintiff has brought an action against the defendant seeking a recovery for injuries sustained in an automobile accident which occurred on or about October 7, 1977 at a time when the plaintiff was a passenger in the defendant's automobile, which was being operated by the defendant in Monroe County. The plaintiff alleged certain specifications of negligence, carelessness, recklessness, willfulness, and wantonness on the part of the defendant. In his answer, the defendant raised as a first defense a qualified general denial and further alleged in paragraph 2 of his answer as follows. Defendant alleges that such accident was not intentional on defendant's part and that defendant denies that he was guilty of reckless, willful, or wanton misconduct in the operation of his automobile within the meaning of the applicable Missouri Guest Statute, section 15-1-290 of the 1976 code. The plaintiff has, and then we have on your 180 lit for your mock, you have Mr. Clark, Sandra, English, Spanish, Mr. Hayes, Officer Tonga, Officer Mandel. Strip search is hyphenated. So this is going to be 180 lit for your mock number 2 for 5 minutes. Ladies and gentlemen, let me tell you one more time that he could not have done it. It could not have happened that way. The defense called Mr. Clark to the stand, and if you recall, he testified that he had employed him this year from May through August or somewhere around those dates. He said it could have been at least up through June of this year and that he worked for him from 8 to 5 every day of the week. If you, ladies and gentlemen, will look at your calendars, you will see that the 10th of June was on a Tuesday. And if it was on a Tuesday, he should have been working. But how can you prove whether or not the defendant was working that day other than by his own testimony? He said he went to work that day and stayed there all day too. His brother left, and when he left, only Sandra was there. I think we can verify it through the records kept by Mr. Clark, but unfortunately it turns out he didn't keep any records of any kind whatsoever. I asked him to keep looking and to come back this afternoon if he could find anything, and he brought back a notebook that had writing in it in both English and Spanish. It was his writing, but it had someone else's writing in it too. That was the extent of the records he kept of the defendant in the month of June. Then, of course, you heard the testimony that he was paid in cash on Fridays, so there would be no check stub or record of that either. I don't think Mr. Clark is lying to us at all. I think he is very sincere in his testimony. And the defendant, Mr. Hayes, did, in fact, at some point in time, and perhaps it was the month of June, work at his place out there. Ladies and gentlemen, I would like to discuss with you the point that Mr. Clark indicated he was gone, that he had things to do, and he wasn't there. He worked as a repairman, and a lot of the time he was away from the place and was out and about taking care of business. He stated to you that the defendant would be out in his truck doing the same thing, repairing washers and dryers and that sort of thing. The defendant just wrote down the hours he worked and gave the slips of paper to Mr. Clark. Evidently, he didn't keep copies for himself, I guess. So what I want to point out, ladies and gentlemen, is that perhaps there was some loose accounting going on there. It sure does look that way. Wouldn't you agree? In other words, the records were not all there, were not kept all of the time, and were not as complete as they could have been. When you don't keep any records, maybe after a period of time, you tend to forget how many hours someone worked for you on a certain date. That is the reason why we keep records, to recall those things, because being human, we don't recall all of those things perfectly all of the time. Mr. Clark seemed to be sincere on the stand, don't you think? I don't doubt that he employed the defendant at some point in time. What you will have to do, however, is weigh the testimony of Mr. Clark against that of Officer Tonga about his identification of the defendant on that date and at that time. If the records and the memory of Mr. Clark appeal to you, ladies and gentlemen, as a reasonable alternative, then the testimony of Officer Tonga is to be rejected. On the other hand, if you feel that the records and the recollection of Mr. Clark are subject to some doubt in your minds and are subject to question, then I think Officer Tonga's testimony is fair to accept. Of course, if you feel both are good and proper, and if you think that both are reasonable, then you should adopt Mr. Hayes' testimony, because if you are in any doubt of any kind, you are entitled to take the reasonable interpretation which points to those things. I ask you, however, to closely examine all angles before you make a determination in this case. You will also want to keep in mind that Mr. Clark is a friend of the defendant's father. Now, I don't know what the relationship is, but there is a family tie of some kind, and they might even want to help by saying something to benefit someone. So I think it is important to consider that also, ladies and gentlemen. Now, let's talk about the heroin that Officer Mandel recovered from the informant. Well, you heard the facts and how they do this sort of thing all the time. I guess it is quite an elaborate kind of search that was done, and it included a strip search as well. In any event, Officer Mandel testified that after the transaction, he met the informant and he turned over a rather large amount of heroin to him. He disclosed the amount, but that is neither here nor there. What I want you to consider is why Mr. Clark was involved in this at all. And then we'll get ready for your 1 minute at 200 jury charge for practice, okay? Members of the jury, it becomes my duty at this stage of the trial to instruct you on the law. I have to go back over very briefly some of the things that I told you at the beginning of the trial, so as to impress those upon you, and so we will all have a clear understanding of our respective duties. I told you to begin with that this man before you has pleaded not guilty to the offense of grand larceny. Because of that, the burden of responsibility is placed on the state to prove him guilty. The state must prove him guilty beyond a reasonable doubt. Now, why is this so? It is because under the laws of this state and of every state in this country, as far as I know, every person who is accused of a crime is always, no matter what the charge may be, presumed to be innocent of that charge until the state proves him guilty by evidence that satisfies you of his guilt beyond a reasonable doubt. Now, this presumption does not stop when you retire to your room, but it accompanies him from the time of his appearance throughout. And then we have on your 200 jury charge, proper names. It says none. Court caput, when you can replace judge in the sentence, okay? Capitalized court. This is going to be 200, number 2. Mock jury charge for 5 minutes, capitalized court, when you can replace judge in the sentence. Members of the jury. The court will usually instruct the jury on the measure of damages in a case, but you are not to think that you are to award the damages just because I have instructed you on this subject. You should not gather any impression from my instructions to you that I, as the court, have any opinion one way or the other whether or not the plaintiff is entitled to any damages. The first question for you members of the jury to determine is whether or not there is any liability on the defendant. You shouldn't address the question of damages until you have reached a decision as to whether or not the defendant in this case is liable. Let me try to explain this to you further. Damages are to be given to the plaintiff if there is liability on the defendant under the facts and under the law, as I will outline to you here. Members of the jury, bear in mind that if your verdict is in favor of the plaintiff, you are to then assess the damages sustained by the plaintiff. If you reach a decision that the plaintiff did sustain damages in this case as so stated, then you must decide if the damages are pertinent or not. In naming the damages, you must consider the extent of the injury sustained. You should also consider the worry or fear, if any, sustained by the plaintiff because of the injuries he sustained. Members of the jury, in deciding the award of damages, you should take note of the medical treatment and doctor visits incurred by the plaintiff and any stay in the hospital or surgery that the plaintiff had to undergo. You may also consider any loss of salary or other income during the time and after the accident in question here today. Also, if it should appear to you that the injuries suffered by the plaintiff harmed his ability to earn a living in the future, then the plaintiff should be compensated for an amount equal to the amount he would have earned had he not suffered in the accident. Members of the jury, from all of the elements I have named, you will determine a sum of money that will fairly compensate the plaintiff. When the law states that a recovery may be made for mental pain, it means that is in addition to the suffering that goes along with the physical pain. Now, if the plaintiff suffers from an ailment that was present before the injuries in question at the hands of the defendant, then you may not consider that ailment when you determine the amount of damages to award. Keep in mind, however, that if an existing ailment of the plaintiff was made worse by the accident in question, then you will take that into consideration in arriving at the sum of damages to be awarded. Members of the jury, to reach a verdict that is fair, you may take into consideration only the testimony and the exhibits that have been received into evidence here in open court. Some things are not evidence, and you may not consider them in any way when you go to deliberate the verdict. For example, any statements made by the attorneys are not evidence, and the attorneys are not witnesses, just as the questions they ask of a witness are not to be considered by you as evidence. The attorneys have a duty to their clients to object when they feel that a question isn't proper under the rules of evidence. What you may have seen or heard when the court was not in session is not evidence either. You are to decide the case only on the evidence received at the trial. Members of the jury, I ask you to bear in mind that contributory negligence is a lack of reasonable care on the part of the person harmed by the negligence of another person and adding to the harm and acting as a proximate cause of it. You jury members will keep in mind that another meaning of contributory negligence is the failure on the part of a person who has been harmed by another person's negligence to use reasonable care to avoid the injury. If a person asking for an award of damages has directly contributed to their own injury, then they cannot be awarded any damages. Members of the jury, I will now give you some more general jury instructions on the law in a case such as this. The law states that a verdict in a civil case must be agreed to by at least 10 of the jury members. That will be enough to bring forward a verdict in this case. At least 10 of you must agree with all of the answers to the questions on the verdict form in order to bring forward a verdict. I am asking you to be unanimous if that is at all possible, but as to any question in the verdict, if your answer is not unanimous, then you will insert the name of each dissenting juror in the blank space at the bottom of the verdict form provided for that purpose. In several questions on the verdict form, the term negligence is used as you will note. A person is negligent when, without any intention of doing wrong, they do an act or omit to do an act that they should have foreseen the risk of. Negligence is often defined as a failure to use that degree of care that ordinary people use. Now, with respect to the questions in the verdict that you have to do with the caution used by the driver of a vehicle, I instruct you that it is the law of this state that the driver of a vehicle is required to keep a careful lookout ahead as they drive on the freeways and highways. That is what careful and prudent people do, and that is what and then we'll have 1 minute at 2:25 practice. Okay, this is going to be 1 minute to 25 practice before your mock Q&A. When you got there, did you know anything about the plant?
Very little.
How did you learn about the plant?
On a day-to-day basis, addressing the problems that arose on a given day.
Did you receive any kind of introductory briefing from the plant manager or anyone else about those problems, or a tour of the plant, for example?
I received a tour of the plant.
An introductory tour of the plant?
Yes.
During your introductory tour of the plant, were you told whether or not there was underground storage tanks at the plant?
I don't remember.
At some point, though, you learned that there were underground storage tanks at the plant. Is that right?
Yes.
How did you learn that?
I don't remember.
Did you ever learn that the names were of any of the underground storage tanks in Denver?
I am sure I did.
Do you know today what the uses were of any of the underground storage tanks in Denver?
I could only conjecture.
I won't ask you to do that at this point. Did you have anyone reporting to you while you were the manager of plant engineering and maintenance?
Yes, I did.
Did anyone who was reporting to you have the responsibility for the condition of the underground storage tanks?
I am sure they did from time to time.
Okay, and then you have on your 225 Q&A, you have Louise O'Brien, Jefferson Avenue, David Jones, Mr. O'Brien, Main Avenue, O'Brien, Jones, Lou O'Brien, Mr. Jones, 22, Judge Jenkins, and Mr. Arnold Z. Rose. And this will be 225 Q&A for your mock number 2 for 5 minutes, you all. And it starts in the middle. Do you know the defendant sitting there?
Yes,
How long do you know him?
a couple of years.
Did you see Louise O'Brien before April 12, 1994?
Yes,
Where did you see him?
in a house on Jefferson Avenue.
Whose house was it?
It was David Jones's house.
How long do you know David Jones?
Oh, for a couple of years.
Was there a discussion between you and Mr. O'Brien at that time about any supermarket at 92 Main Avenue?
There was.
Tell us in your own words what the conversation was that you had and who said what.
I don't remember. I can't remember.
Do you remember what was said about 92 Main Avenue?
Yes.
What was said?
We were discussing the layout of the place and how many people worked in there, and it would be best to go and look it over.
What was the purpose of your surveying it?
We were going to rob it.
Did there come a time that you and Mr. O'Brien met after this appointment in Jones's house that you told us about?
No.
Did you see him April 12, 94?
Yes.
Where did you see him?
Downstairs on Main Avenue.
Who, if anybody else, was there?
Me, O'Brien, and Jones.
Tell us what happened. By the way, what time in the morning did you meet, if you recall?
7:30.
What happened after that you recollect seeing with your own eyes?
I went in the store to find out how many people were in there. After casing the place, I bought some orange juice and a newspaper and went back upstairs. I came back down. Jones was coming out of the store. He had been shot in the leg.
Did you see O'Brien?
Not until after he came out of the store.
Did you see him exit the store?
Yes, I did.
Did you see a weapon?
All he had was a bag.
He had a package?
Yes.
Anything else in his hands?
No, I didn't see nothing else.
What kind of package was it?
A regular paper receptacle.
Were you there when O'Brien and Jones went into this store?
I went upstairs.
Did you see O'Brien go into the store?
The last time I seen him is when he came out of the store.
You went into the store and bought something.
Juice and a paper.
Then what?
He left. I told him how many people were in the supermarket.
In other words, you met them on the way out.
They piled into the car.
Where?
On the corner.
Whom did you talk to?
I talked to Jones and O'Brien.
Was there any discussion about a weapon by Jones or O'Brien?
No talk.
How many people were in the supermarket?
2 customers
Anyone else?
and the owner.
Did you know the proprietor?
No, sir.
What did you do with the juice and paper?
I went to my apartment
Where?
across the street.
At what address?
67 Main Avenue,
What floor?
21st floor.
You took the elevator upstairs?
Yes.
Then came downstairs.
Yes.
What time was that?
After 8,
Where did you go when you came out of there?
I peered in the car.
Was anybody there?
No.
Then where did you proceed?
I slouched around at the corner.
How far is the corner from the supermarket entrance?
I think about 7 doors away from the exit.
Then what happened?
I kept the supermarket from under surveillance,
What else were you doing?
looking out for the police.
So you were playing lookout, true?
Yes.
Did you hear any shots fired?
No.
Did there come a time when you saw Jones and O'Brien?
I did.
Whom did you see first?
Jones.
What was he doing?
He was limping
Where was he coming from?
from the supermarket.
The supermarket?
Yes, right, sir.
You say he was limping?
Limping.
What else did you see?
He had a blood stain on the knee part of his trousers.
Was he carrying anything in his hands?
He was empty-handed as far as I saw.
Was he running?
He was like hobbling along
In what direction was he limping?
towards me.
How soon after you saw David Jones did you see Lou O'Brien?
About 10 or 11 minutes.
What was he doing?
He had a bag,
What was in the bag?
silver coins.
You saw that?
I saw that.
Did he have any bills? Did he have any 1s, 5s, 10s?
Not those, no.
Have you told us everything in your remembrance?
Just about.
With respect to this robbery, did you expect to receive a share of the loot?
No,
There was no agreement to that end?
no.
What did you do with the bleeding Mr. Jones?
I took him to the cab back to this house.
Did you have a weapon on you?
I did not.
Did you see guns or knives or switchblades?
Well, I saw a 22.
Who had it?
O'Brien had it
Where?
inside his belt on the side of his hip.
When did you see that?
April 12.
Before they came out of the supermarket?
Before.
How soon before?
Before I went upstairs.
You ultimately pleaded guilty to a homicide, that is manslaughter in the first degree.
That is correct.
At that time, did Judge Jenkins ask you certain questions about your participation in the case?
He did, yes.
At that time, did the judge ask you if you were supposed to get a cut of the robbery proceeds?
I told him I was expecting something.
You told him what?
It wasn't mandatory that I get it.
Did you say that it was not mandatory?
No.
Sir, Mr. Arnold Z. Rose was your lawyer, is that right?
He was.
You talked with him before taking this plea to manslaughter in the first degree, is that right?
Correct.
Were you reluctant to take the plea? Yes or no?
No.
You wanted to?
I wanted to.
Were you looking for a break?
I was expecting it.
You were expecting what?
A little leniency on sentence day.
That means a break, doesn't it?
Well, consideration.
Did your lawyer discuss that with you before you took the plea?
He discussed the plea.
Did he discuss consideration?
He told me there was no promises.
No promises, is that right?
That's right.
But you had in the back of your mind the hope
On my own.
on your own.
Yes.
You figured if you cooperated, you would get a break.
Yes.
Or hope so.
I was hoping that I would get a break.
Is that right?
Yes.
Were you innocent?
Not exactly.
Were you involved in the stick-up question? And I was saying Louise, y'all, it's Lewis, okay? And Maine, how was Maine spelled? Just right there.
M-A-I-N.
Okay, there
Just
was no
regular.
E at the end. Okay. Okay, you all, so that's it. Good luck. I will send you all emails about registration. Make sure that you all type up your mocks if you're going to get them graded before Wednesday midnight. Okay? Have a great day, you all. And I'll send you emails about registration. Practice. Keep on practicing. EV 360 will still be available to you all over the break. So use it.